Hi, I'm Alice Glendening. I'd like to welcome you to a new school at USD 440 Halstead Middle School and a school year with fresh beginnings. I'm going to begin by reminding you of an extremely important law. The name of this law is FERPA. Now that sounds like something bad, doesn't it? It can be if you don't follow it. Teachers' behaviors. Let's begin by reflecting on our past behaviors. Have you ever gone into the teacher's lounge and said, "I can't believe Sally Sue. No wonder she never passes the state assessments." Or gone home and said the same thing to your family or friends? Are you revealing personal information and compromising confidentiality? Did you know you are violating the FERPA law? What is FERPA? What exactly does this strange word mean? FERPA is Family Educational Rights and Privacy Act. Public Law 93-380, the Family Educational Rights and Privacy Act, FERPA, protects confidentiality of student records. This act, commonly referred to as the Buckley Amendment, was enacted by Congress in 1974 to guarantee parents and students a certain degree of confidentiality and fundamental fairness with respect to the maintenance and use of student records. No funds shall be available under any program to any educational agency or institution which has a policy of denying access or which effectively prevents the parents of students who are or have been in attendance at a school of such agency the right to inspect and review the educational records of their child. This statement was taken from the Buckley Act. If a student is 18 years of age or attends a post-secondary institution, parental consent is not required. Now, if they're still a dependent for tax purposes, parents retain a coextensive access right. A school official should be present to assist a parent or guardian in interpreting information obtained in the files and to respond to questions that may be raised. Parents or legal guardians also may challenge the accuracy of any information found in the files regarding their child. The school must schedule a conference within a reasonable period after the request with appropriate personnel to discuss the information that may be deemed inaccurate, inappropriate, or misleading. If agreement is reached to the satisfaction of the parent, no further action is necessary. Appropriate deletions or corrections are executed, recorded in the student file, and communicated to parents or guardians in written form. If the conference does not result in changes to the satisfaction of parents, they may request a formal hearing with the Director of Pupil Personnel or a designee to appeal the decision reached during the conference. The parent or guardian may be represented by legal counsel. If the school official hearing the case decides that the information is accurate and correct, the parent must be informed and provided an opportunity to place statements of disagreement in the file, together with reasons for the disagreement. This explanation must become a permanent part of the record and must be disclosed when the records are released. The parent or guardian may also seek relief in civil court. The right is also extended, these rights are also extended to the 18-year-old student. However, FERPA does allow schools to disclose records without consent to the following parties or under the following conditions: school officials with legitimate educational interest, other schools to which a student is transferring, specified officials for audit or evaluation purposes, appropriate parties in connection with financial aid to students, organizations conducting certain studies for or on behalf of the school, accrediting organizations, to comply with a judicial order or lawfully issued subpoena, appropriate officials in cases of health and safety emergencies, and state and local authorities within a juvenile system pursuant to specific law. Directory information schools may disclose without consent directory information, such as a student's name, address, telephone number, date and place of birth, extracurricular activities, weight, height, and membership on athletic teams, honors and awards, and dates of attendance. The schools must tell the parents, however, and eligible students about the directory information and allow the parents and eligible students a reasonable amount of time to request that the school not disclose said information about them. Sometimes controversy arises regarding the rights of a non-custodial biological parent to access his or her child's education records. In that case, schools or district policy normally provide the guidance in these situations, and there was a district court case in New York where it was decided neither parent could be denied access to this child's records under FERPA. Records should be accessible to both parents of a child fortunate enough to have both parties interested in the child's welfare. In the rights of school personnel, teachers, counselors, and administrators who have a legitimate education interest in viewing records may do so. If challenged, school personnel must demonstrate a legitimate reason for having reviewed the student's files. Also, institutions are not prevented from disclosing such information to school officials who have been determined to have a legitimate educational interest in the behavior of the student. School districts also are permitted to disclose information regarding disciplinary actions to school officials in other schools that have a legitimate educational interest in the behavior of students. Peer grading does not violate FERPA. If records or files have been reviewed, the files need to have a form that has who reviewed them and the date that they were reviewed. Defamation by school personnel. Slander, libel, privilege, good faith, acts of malice. Slander is oral defamation, which occurs when school personnel inadvertently communicate sensitive and damaging information contained in student files to others who have no need to be informed. Libel, unlike slander, is written defamation. Teachers, counselors, and principals should refrain from including in the student's record damaging information for which there is no basis. Any information recorded should be factual and specific with respect to serious infractions committed by the student. Privilege. When school personnel share information regarding information about a student that could be in their file, they are protected by qualified privilege. Those personnel could be subject or grade level teachers, counselors, or administration. Good faith required that a legitimate purpose be reserved by communicating the information, and acts of malice exist when there is intent to harm or injure another. When statements are communicated regarding a student, either written or oral, with the intent to injure his or her reputation, a torturous act has occurred, especially if the statements are false. Thank you. This has been a brief explanation of Public Law 93-380, the Family Educational Rights and Privacy Act.